Okay, I was talking to a couple gentlemen. They got a little upset with me. Pretty much said I sounded like a dick. They wanted to hang up on me, but it was about probate court, and I was trying to give them an easy way out. And I kept trying to discuss the rules, and they just wanted to discuss the case. And one of them already knew about the rules, and he says, "No, this isn't a criminal case. This is probate." And I says, "No matter what kind of court it is, probate, conservatorship, guardianship, any kind of civil case, any criminal case, federal, state, it doesn't matter. The rules of professional conduct and the code of judicial conduct are the common denominator in every court." So here he is complaining about the lawyer's lack of diligence, no communications, the outstanding fees, the confidentiality of information. Basically, the lawyer told him the only thing he needed to know was he didn't need to know, which is illegal. Conflict of interest, current clients, representing multiple clients or past clients, client with diminished capacity, you can claim that. Client with diminished capacity, because they need to get informed consent from you. In order to get informed consent, you need reasonable knowledge to make an informed decision to give informed consent. And considering you're competing against your own attorney and the opposing party as well as the judge, the only reasonable knowledge you would be able to give would be the legal knowledge that equal to your attorney, the judge, the opposing party, because nobody's abiding by the rules or the codes. You don't even know they exist, or these are the laws within a court of law and that nobody's doing. So in order to receive that informed consent, you need the legal knowledge of all those you're up against. You need a degree. You don't have that. You don't have the legal knowledge to make an informed decision to give informed consent. So you can quite easily claim client with diminished capacity, safekeeping property. They don't do that. He's talking about what they're doing with grandma's property, his mom's property. The kid that I was talking to, his grandma, nice kid, nice grandma. I met her once, and so they're worried about the more they talk to the attorney's talking about quitting, and the more they question. So I try to explain to them declining or terminating representation. There are legal boundaries, and he can't just drop you just like that. But he said, "Let me explain the case to you." I said, "But see, this is where you want to explain the case, not to me, but to the courts. You can literally go into court, tell the judge, do this job, cite the attorney for all these violations, because that's their job, and we'll get to it eventually. I'm going to try to make this as quick as possible." Advisor, they don't do that. I'll get to all the definitions, don't worry. Meritorious claims and contentions, expediting litigation, candor toward the tribunal, fairness to the opposing party and counsel, trial publicity, special responsibilities of prosecutor, which is still basically for all lawyers. You could use the language in that. That means truthfulness in statements to others, dealing with unrepresented persons, making sure that your lawyer does all this, because that's misconduct, and reporting misconduct is mandatory. And it's also mandatory that the state's attorney and your judge sees to it that your attorney lives up to the code or the rules of professional conduct. That's where deprivation of rights starts, with your attorney. In a conspiracy against rights under the color of law, it starts with deprivation of rights, and that deprivation of rights with your attorney not explaining to you the rules of professional conduct or reviewing them within such a manner that I'm doing so myself. Okay, so that's where you come in and use the codes. A judge shall perform the duties of judicial office impartially, competently, and diligently. Rule of Canon 2, Rule 2.15, responding to judicial and lawyer misconduct. Judge knowing that another judge has committed a violation of this code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge, or in other respects, shall inform the Illinois Judicial Inquiry Board. A judge knowing that a lawyer has committed a violation of the Illinois Rules of Professional Conduct or raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the Illinois Attorney Registration Disciplinary Commission. See, so everybody's supposed to report each other. The judge is supposed to report your attorney, the opposing party, because the opposing party didn't report your attorney for ineffective assistance of counsel for violating the rules of professional conduct when it came to assisting you in your endeavors, your legal endeavors. Okay, so everybody's supposed to report everybody. And that's where this will make sense. Okay, I'm going to close it. See, this is what I tried to tell judges. They won't let me get it on the record. So let's see if any of you can use this, okay? Don't matter what court you're in. Throw that on a motion to quash. Conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct, code of judicial conduct. Failure to report misconduct, just as well as failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel does not allow for a fair trial, which shows due process didn't exist. A deprivation of rights in its entirety. It clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law, which prohibits the willful deprivation of rights, privileges, or immunities under the color of law, which prohibits conspiracy to injure, oppress, threaten, or intimidate any person in free exercise or enjoyment of any right or privilege secured by the Constitution or laws of the United States. I trust you will live up to your oath and show competence, diligence in expediting litigation, as I have meritorious claims and contentions. So I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communication will be made for ethical violations and every penalty will be imposed in the public interest as trustees. This is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. Okay, so a young lady asked me, she had to fill out a complaint form. I told her to Google a conspiracy against rights under the color of law complaint form. It took her to the DOJ website, Civil Rights Division, and she had to do it in under 500 words or less. So that was the best I could do. That was the best I could do. Now, I tell people, you see, like this guy, I got him out here.
My attorney for ineffective assistance of counsel. Reporting misconduct is mandatory in both the Code of Judicial Conduct as well as the Rules of Professional Conduct. The state's attorney should as well then, Your Honor. You took an oath of public service, and violation of that oath is treason. Not to cite my attorney and the state's attorney for violating the Rules of Professional Conduct is a violation of that oath. In judicial conduct, you are also legally obligated and required by the Code of Conduct to do so. My attorney and the state's attorney are therefore required to cite you for judicial misconduct upon failure to do so. Informed consent is required before these proceedings can go forward. It is required I have reasonable knowledge to give informed consent, and that reasonable knowledge would be informing me exactly what due process is, and that's explained in the Rules of Professional Conduct and the Code of Judicial Conduct. A fair trial would require everyone in a court of law making sure that I have reasonable knowledge to give informed consent. Now, effective assistance of counsel is a double-edged sword and cuts every way you swing. Every attorney is required to abide by and enforce the rules of conduct as well as judges. Every lawyer and judge are required to abide by and enforce the Code of Judicial as well. Preferential treatment is forbidden in every court of law, and thus far you have given my attorney and the state's attorney preferential treatment, and they you. Let's not forget the requirements of a quick and speedy trial, which has limits. No one has explained any of this to me. With this being recently discovered, I ask that this case be dismissed with prejudice and for all of you to do what's required of law and report each other to the proper authorities. Thank you, Your Honor.
Talk about American badass, huh? I threw him a whole bunch of links, and he just shortened it, you know. See, deprivation of rights is a criminal act punished with fines, removal of public service, and incarceration. That's a violation of the rule of law and punishable with fines, removal of public service, and incarcerations. You can hold me to the letter of law, and that violating the letter of the law is punishable with fines, removal of public service, and incarcerations. That's violating the oath. Mandatory fines, removal of public service, and incarcerations. Don't get me started on ethic violations. I like to talk a lot. Imagine if public servants were actually held accountable for the crimes they commit. Imagine if our public servants lived up to the basic obligations of public service. Imagine, if you will, not living under the color of law led by a corporatocracy. Corporacy refers to a society, a system where large corporations hold significant economic, political, and sometimes judicial power and influence over government and other social aspects. It's a blend of corporate and Greek suffix "krisi," meaning rule or government. Key characteristics of a corporacy: corporate control. Corporations wield substantial power, influence in controlling social, economic, and political structures. Living under corporate rule, that sucks. Look at this, 250 years. Almost. Next year, next July. 250 years, and it still hasn't happened. Seen two gentlemen talking about on the internet. What would one tell the other? What do you think would stop racism? He said, quit talking about it. No. You gotta keep talking about it. You gotta keep talking about why hasn't this happened yet. If this has happened, you know, they offered this before writing the Declaration of Independence because the British offered to their slaves first to help fight the colonists. So the colonists offered it to their slaves. They offered it to also freed black men and women joined in at Valley Forge, as well as enslaved black men. All the immigrants, Russian, Germantown, several different native tribes joined in at Valley Forge. But after the Constitution was written, or when the Constitution was written, they retracted it, and still today, you know, a nation of laws, if there was a king, it would be the rule of law. I find this the most poetic version of the rule of law there is. In a nation of law, bow to the king. the Constitution as a supreme land, the U.S. Constitution calls itself supreme law of the land. This clause is taken and meant that the state constitution or law passed by the state legislators or national Congress are found to conflict with the federal Constitution. They have no force. What happens when any law that goes against the Constitution, any law repugnant to the Constitution, is void? With these words written by Chief Justice Marshall, the Supreme Court for the first time declared unconstitutional law passed by Congress and signed by the President. In this intricate system, the role of the Supreme Court had not been defined. Okay, so I just want to make some things clear to you, okay? Not knowing the rules of professional conduct and the code of judicial conduct exists, not caring the rules and code exist. Okay, so let's go here real quick, okay? Misconduct. Misconduct is violating any of the rules of professional conduct or the code of judicial conduct. Okay. Professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or so through the acts of another, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer, or other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. There's so much you could knowingly assist a judge or judicial officer in a conduct that violates applicable rules of the judicial code or other law. Okay, so the rules and the codes are laws. Okay, so violating any of the rules is misconduct. Reporting misconduct is mandatory. A lawyer who knows that another lawyer has committed a violation of the rules shall inform appropriate professional authority. A lawyer who knows the judge has committed a violation of applicable rules of judicial conduct that raises substantial questions as the judge's fitness for office shall inform the appropriate authority. But they don't do that. Okay, so and I already went over so many of the rules that they violate. So lawyers and judges, they'll act like you don't know what you're talking about. So you got to take this with you and make sure. Truthfulness statements to others. In the course of representing a client, lawyers shall not knowingly make false statement of material fact or a third person, or fail to disclose material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. So if you want your lawyer to do something illegal and they know it's illegal, it's their duty to tell you and not do it. They could actually withdraw from your case, citing that you want to do something that's illegal. It's special responsibilities of the prosecutor. I told you could use the language of that. In any case, in the duty of public prosecutor shall seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. Make reasonable efforts to ensure that the accused has been advised of the rights to a procedure, obtaining counsel, and has been given reasonable opportunity to obtain counsel. Not seek to obtain from unrepresented accused a waiver of important pretrial rights, such as a right to a preliminary hearing, also known as a probable cause hearing. And nobody will even talk to you about that. Okay, then you go all the way down here. When a prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of an offense that defendant did not commit, the prosecutor shall seek to remedy the conviction. People ask me, where can they got exculpatory evidence? Can you find me an honest lawyer? Well, you take the law and you go to the prosecutor's office. It's their job. It tells you, all right, probably disclose that evidence to the appropriate court or authority. If a conviction was obtained in prosecutor's jurisdiction, properly disclose that evidence to the defendant unless the court authorizes delay. But they won't disclose any of that exculpatory evidence. And I don't know why you have to constantly remind them, state's attorney is his official capacity as representative of all the people, including the defendant, as much as his duty to safeguard the constitutional rights of the defendant and those of any other citizens. People versus Cochran, 1935, the United States Supreme Court described the duty of a federal prosecutor in the following passage. The United States attorney is a representative, not of ordinary party or controversy, but a sovereignty whose obligation to govern impartially and compelling as it is obligation to govern at all, whose interest therefore a criminal prosecution is not, and it shall not win a case, but justice shall be done as such. Now you could use that language in any court and just leave out the prosecution part, the criminal prosecution. It could be a prosecution in child court or custody, or you're being deprived of life, liberty, and your pursuit of happiness and conservatorship. Probate court, they're just playing the procrastination game for billable items. That's a whole lot of procrastination there. Definite case, servant shall serve the law, the twofold aim, which is to seek the guilt shall not escape or innocent suffer. He may prosecute with earnestness and vigor, indeed, he should do so, but while he may strike hard blows, he is at not liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction, and it is used every legitimate means to bring about a just one. Yeah, like that's going to happen, right? But if you don't know this, it ain't going to happen. Partiality and decorum, you already know what that means. But they're going to act stupid. So you're going to have lawyers shall not seek influence of judge, jury, prospective juror, judicial office means by prohibited by law, communicate ex parte with such a person during proceedings unless authorized to do so by law, communicate with the juror, prospective juror after discharge of the juror if. Okay, so there's a lot of things they shouldn't do, but they do. Candid towards a tribunal, you know what that means, right? Lawyers shall not knowingly make false statements, lawyers or judges. Expediting litigation. Lawyers shall make reasonable efforts to expedite litigation consistent with the interests of the client. That's what the guy was complaining about. Took years. It shouldn't have took years. Remember, you have meritorious claims and contentions, and citing your attorney for ineffective assistance counsel for his failure to expedite litigation, the failure of candid towards the tribunal, and the opposing party showed no fairness by his failure to cite my attorney for ineffective assistance of counsel. You can go on and on. We haven't even got the safekeeping property. So if you're in conservatorship, guardianship, probate, okay, lawyer must not even temporarily use funds or property of clients or third persons for a lawyer's own purposes without authorization. Okay, so there's a lot you're going to want to read there, okay, because they don't do that. And I've talked to so many of you, especially in probate court, and none of this is happening. Some lawyers are getting really, really overdoing it, and are finally, but not everybody. I want accountability. No, a Pokemon thing. What do they call that? Gotta catch them all. Pokemon something, some game I seen on TV or the internet. But yeah, we got to catch them all. Nobody, zero tolerance, people. We want zero tolerance. Conflicts of interest, duties to former clients, because duty to former clients is usually violated when there's conflicts of interest because they're taking on another client in the same case and may be using information that you may have shared with your lawyer, and they won't abide by that confidential of information because they may use it against you to win the case for the other guy they took up with. Okay, communication is mandatory. Okay, a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent. Remember I told you about informed consent? In order for it to go forward, they need to get informed consent. In order to get informed consent, that you need reasonable knowledge. You need reasonable knowledge to make an informed decision to give such informed consent, but you don't have that because nobody's telling you nothing. So you promptly comply with reasonable requests for information. Consult with the client about any relevant information the lawyers conduct when the lawyer knows that the client expects assistance not permitted. Lawyers shall explain the matter of the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Diligence. Everybody, judges, lawyers shall act with reasonable diligence, promptness in representing a client. So that there tells you that you are entitled to a quick and speedy trial. Diligence, no matter what case you're in. Diligence, expediting litigation, communication. It would be competent to be diligent in expediting litigation. Competence. And then when you go over the preamble and the scope, my God, there's so much you could use there. The lawyer's member legal profession is representative of the client in office, legal system, and public citizen having special responsibilities for the quality of justice. It reads like a Boy Scout handbook. It does. To the extent all lawyers meet obligations of their profession, calling the occasion government regulation is obligated. Self-government also helps maintain the legal profession's independence. And for those of you that filed in Illinois with the ARDC or Judicial Inquiry Board, you know it's a relentless effort. I've been laughed at by attorneys and judges. So it's easier to get a cop, to arrest a cop. Okay, that's the rules of professional conduct. Okay, so your lawyer ain't, so you can literally go tell the judge, hey, do your job. Okay, that's the rules of professional conduct. View the code. Report and recommendations, they don't do shit. Okay, we're going to go down to Canon 2, code 2.15. Okay, this is Canon 2, Rule 2.15, responding to judicial and lawyer misconduct. A judge knowing that another judge has committed a violation of the code that raises a substantial question regarding a judge's honesty, trustworthiness, or fitness. Okay, a judge knowing that a lawyer has committed a violation of the rules of professional conduct. Okay, so you're going to tell the judge, do your job. Okay, your failure to report my attorney for ineffective assistance of counsel in the opposing party for multiple violations of the code or the rules of professional conduct is in contempt of the very court you preside over. It's furthering a conspiracy against rights under the color of law. You are legally obligated to report this. These are not only my constitutional rights, but your constitutional duties. Violating the rules or the codes are violating the oath, and to interpret this in any other fashion or form other than it is written is violating the letter of the law. Thus, in every law you violated the king of law, the rule of laws. You did not treat me as an equal. You treated me as less than, not deserving of my constitutional rights, the Bill of Rights, my human rights as a United States citizen, my birthrights. Okay, so we're going to go to the top because they violate that code. They violate just about everything. You're going to want to go through the preamble because that'll tell you a lot of stuff they're supposed to do that they don't do. That'll take a little while to read through. I want to make this as short as possible. So I'm just going to go over these big guns. I still call the canons, the Code of Judicial Conduct and the Rules of Professional Conduct, big guns. When you go to court, you got to take the big guns. The rules are some big guns. If you want to blow them out of the water, then that's when you hit the cannons. You pull out your cannons. Judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all the judge's activities. Okay, compliance with the law. Judge shall comply with the law, including the code. That means reporting misconduct on behalf of all those attorneys and themselves for violating the code for not reporting the attorneys. It's mandatory to report misconduct. Failure to report is misconduct. And it doesn't limit who the judge has to report. The judge has to report any lawyer or any judge violating the rules and the codes. That would promote confidence in the judiciary. But they aren't doing that. They violated that. So, and they're all complaining, hey, the public has no confidence in us. Well, that's because you're not doing your job. People, this is law. Avoiding misuse. Well, not reporting any violations is misuse. So they violated Rule 1.3 of Canon 1. So this is a lot of laws they're breaking. That's what that guy said in the short video. He threw a lot of laws at them. And these are a lot of them that he threw at them. Judge shall perform the duties of judicial office impartially, competently, and diligently. No procrastination, but why do they allow the lawyers to procrastinate? If you've ever been in a court of law, I've been many a times, mostly as a spectator. Court starts maybe 10 o'clock, ends just before 12. They may come back about 1:15, 1:30 for an hour, and that's about it. The scales of justice should be under their butt. They only get paid for the minutes they are on the bench, sitting. giving precedence to the duties of judicial office, impartiality and fairness. If they aren't abiding by the codes and enforcing the rules as well as the codes, they violated Rule 2.2. Now, reporting those attorneys showed bias, favoritism towards the attorneys, prejudice towards you. And because you didn't accept the plea bargain, you got a lot of harassment. They doubled up on the charges, increased the time that they were threatening you with. And still yet, a lack of probable cause. External influences on judicial misconduct, that comes in many forms. Competence, diligence, and cooperation. If you're not abiding by the code of judicial conduct, that's a lack of competence. Failure to report everybody for all this misconduct in a timely fashion, lack of diligence. Cooperation. The public trust doctrine commands that you do what's in the public interest. You're not doing that. Assuring the right to be heard. A judge will try to stop you, tell you, let your lawyer talk. So you're going to want to use Rule 2.6 because you're going to tell the judge, you're going to take this to you, ensuring the right to be heard. A judge shall accord to every person who has legal interest in a proceeding that a person's lawyer the right to be heard according to the law. So you have the right to be heard. Responsibilities to decide. The judge shall hear and decide matters assigned to the judge except when disqualification is required. Well, they aren't going to cite themselves for judicial misconduct, and the lawyers for violating the rule of professional conduct law should recuse themselves. Decorum, demeanor, and communication with jurors. Do they ever explain their legal obligations in a court of law to the participants in that court, to the jurors? I had to do jury duty, and they didn't want me because I wanted a copy of the rules, codes for everybody. Responsibilities of the jurors, and they decided they didn't want me. I wasn't trying to get out of jury duty. I was making sure whoever was being tried got a fair trial. So many ways. So in the rules and the codes you could use to disqualify a judge. If they aren't seeing to it that the lawyers are living up to the rules of professional conduct, they aren't living up to the code of judicial conduct. Everybody should be disqualified. Supervisors' duties. Supreme Court judges are supposed to make sure everybody underneath them, by the rules, the codes, etc. Everything I'm telling you. And here we are again, responding to judicial order of misconduct. So you tell the judge to do your job. Your failure to do so is adding to this conspiracy against rights under the color of law. Everybody here is guilty of deprivation of rights. I just proved it. Well, that's what you're going to say. Tells you a lot of stuff like how they got to report their earnings. People, there's a lot to learn. I'm sorry I'm rushing through this. But I'm trying to make my videos as short as possible because I'm trying to get you to open your mind. Okay, reporting requirements. A judge shall file annually with the clerk of Illinois Supreme Court verified written statement of economic interest. The content filing deadline shall be specified by administrative order of the court. This is a judge's job description. Okay. Okay, folks, there's a lot to learn. You can use anything I talk about for your own videos. I try to encourage people to do that. Process proceedings before the courts, commissions, commission cases, rules. See, like when you go for the code of judicial conduct, trying a lot of stuff for years, folks. I think I've been blackballed. But this is where you find you're supposed to be able, says the request for an investigation process. My first complaint was a double jeopardy clause violation in 1980 or something, and violating my right to a quick and speedy trial. But I didn't have the rules and the codes as of yet. And then when I got them, I already filed. So then I just kept throwing stuff at them. So, you know, and I'm surprised they answered me at all. I only got an answer from the Illinois ARDC, Attorney Registration Disciplinary, once. And all they did was talk me down. You lawyer? Nope. Get the hell out of here. And no matter what, I've been to the FBI, complained to the DOJ, filed the Supreme Court, federal court. I didn't know where. Clerks told me, no, you got to know. Otherwise, we ain't doing it. I didn't have the legal education at that time. But now with the help of the internet, and I used the internet several years ago, filed with the ARDC and Judicial Inquiry Board. Got no response. The ARDC, the Judicial Inquiry Board, I filed on paper. No response to that. I'm going to keep doing it. It's a whole lot your lawyer ain't doing, right? If you're paying him, maybe you'll get lucky. Him or her. Like I said, I don't mean to sound mean, but when you go to talk to a lawyer before you step into a court, if you don't take the rules and codes with you, learn that stuff, take some KY jelly. Drop them drawers and just bend over and let them have their way. At least tell them put some Hawk 2 on that. You want to spit. I'm pretty sure it's going to hurt. But protect yourself. Learn what your right to due process is. Learn what your right to a fair trial is. Learn what due process is. Learn what effective assistance of counsel is. Okay, remember, always hold the letter of the law dear to your heart, okay? So that way nobody tries to misinterpret anything you say. Remind them of the penalties for violating the letter of law. Nothing but peace and love to you people. I wish you a long life, good health. May your Creator always be with you and rain many blessings. Good night and good health.